The United States Department of State quoted the IHRA working definition of anti-Semitism as follows. Anti-Semitism is a certain perception of Jews, which may be expressed as hatred toward Jews. Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and/or their property, toward Jewish community institutions and religious facilities. To guide IHR in its work, the following examples may serve as illustrations. Manifestations might include the targeting of the State of Israel, conceived as a Jewish collectivity. However, criticism of Israel similar to that leveled against any other country cannot be regarded as anti-Semitic. Anti-Semitism frequently charges Jews with conspiring to harm humanity, and it is often used to blame Jews for why things go wrong. It is expressed in speech, writing, visual forms, and action, and employs sinister stereotypes and negative character traits. Contemporary examples of anti-Semitism in public life, the media, schools, the workplace, and in the religious sphere could, taking into account the overall context, include, but are not limited to, calling for, aiding, or justifying the killing or harming of Jews in the name of a radical ideology or an extremist view of religion. Making mendacious, dehumanizing, demonizing, or stereotypical allegations about Jews as such or the power of Jews as collective, such as, especially but not exclusively, the myth about a world Jewish conspiracy or of Jews controlling the media, economy, government, or other societal institutions. Accusing Jews as a people of being responsible for real or imagined wrongdoing committed by a single Jewish person or group, or even for acts committed by non-Jews. Denying the fact, scope, mechanisms, for example, gas chambers, or intentionality of the genocide of the Jewish people at the hands of National Socialist Germany and its supporters and accomplices during World War II, the Holocaust accusing the Jews as a people, or Israel as a state, of inventing or exaggerating the Holocaust, accusing Jewish citizens of being more loyal to Israel or to the alleged priorities of Jews worldwide than to the interests of their own nations, denying the Jewish people their right to self-determination, for example, by claiming that the existence of a state of Israel is a racist endeavor, applying double standards by requiring of it a behavior not expected or demanded of any other democratic nation, using the symbols and images associated with classic anti-Semitism, for example, claims of Jews killing Jesus or blood libel, to characterize Israel or Israelis, drawing comparisons of contemporary Israeli policy to that of the Nazis, holding Jews collectively responsible for actions of the State of Israel. Anti-Semitic acts are criminal when they are so defined by law, for example, denial of the Holocaust or distribution of anti-Semitic materials in some countries. Criminal acts are anti-Semitic when the targets of attacks, whether they are people or property, such as buildings, schools, places of worship, and cemeteries, are selected because they are, or are perceived to be, Jewish or linked to Jews. Anti-Semitic discrimination is the denial to Jews of opportunities or services available to others and is illegal in many countries. On May 1, 2024, the House of Representatives passed Bill H.R. 6090, which, if it becomes law, will incorporate the International Holocaust Remembrance Alliance definition of anti-Semitism into Title VI of the Civil Rights Act of 1964. This unconstitutional legislation is meant to have a chilling effect on free speech, which is critical of Jews, Zionism, and the nation of Israel. Christians oppose the proposed law on the basis that it will suppress both their freedom of speech and their freedom of religion. The bill has also met strong opposition in the MAGA and Christian nationalist camps of the Republican Party and by Palestinian rights activists. However, this legislation is merely an expanded codification into federal law of Donald Trump's Executive Order on Combating Anti-Semitism of December 11, 2019, which Trump signed at his White House Chanukah celebration. The New York Times reported that Trump's Executive Order on Combating Anti-Semitism was in turn made at the behest of Trump's Jewish son-in-law, Jared Kushner. Trump clearly supports this unconstitutional measure to suppress free speech, and he places the interests of a hostile foreign power above those of American citizens exercising their fundamental human rights to free speech. Under pressure from Jared Kushner, then President Donald J. Trump signed his Executive Order on Combating Anti-Semitism, which states as follows: By the authority vested in me as President by the Constitution and the laws of the United States of America, it is hereby ordered as follows. Section 1. Policy. My administration is committed to combating the rise of anti-Semitism and anti-Semitic incidents in the United States and around the world. Anti-Semitic incidents have increased since 2013, and students in particular continue to face anti-Semitic harassment in schools and on university and college campuses. Title VI of the Civil Rights Act of 1964. Title VI, 42 U.S.C. 2000 D.A.T. Seek, prohibits discrimination on the basis of race, color, and national origin in programs and activities receiving federal financial assistance. While Title VI does not cover discrimination based on religion, individuals who face discrimination on the basis of race, color, or national origin do not lose protection under Title VI for also being a member of a group that shares common religious practices. Discrimination against Jews may give rise to a Title VI violation when the discrimination is based on an individual's race, color, or national origin. It shall be the policy of the executive branch to enforce Title VI against prohibited forms of discrimination rooted in anti-Semitism as vigorously as against all other forms of discrimination prohibited by Title VI. Section 2. Ensuring robust enforcement of Title VI. A. In enforcing Title VI and identifying evidence of discrimination based on race, color, or national origin, all executive departments and agencies charged with enforcing Title VI shall consider the following. 1. The non-legally binding working definition of anti-Semitism adopted on May 26, 2016 by the International Holocaust Remembrance Alliance, IHRA, which states, anti-Semitism is a certain perception of Jews which may be expressed as hatred toward Jews. Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and/or their property, toward Jewish community institutions and religious facilities. And 2, the contemporary examples of anti-Semitism identified by the IHRA, to the extent that any examples might be useful as evidence of discriminatory intent. B. In considering the materials described in subsections A1 and A2 of this section, agencies shall not diminish or infringe upon any right protected under federal law or under the First Amendment. As with all other Title VI complaints, the inquiry into whether a particular act constitutes discrimination prohibited by Title VI will require a detailed analysis of the allegations. Section 3. Additional authorities prohibiting anti-Semitic discrimination. Within 120 days of the date of this order, the head of each agency charged with enforcing Title VI shall submit a report to the President, through the Assistant to the President for Domestic Policy, identifying additional non-discrimination authorities within its enforcement authority, with respect to which the IHRA definition of anti-Semitism could be considered. Section 4. Rule of construction. Nothing in this order shall be construed to alter the evidentiary requirements pursuant to which an agency makes a determination that conduct, including harassment, amounts to actionable discrimination, or to diminish or infringe upon the rights protected under any other provision of law. Section 5. General provisions. A. Nothing in this order shall be construed to impair or otherwise affect 1. The authority granted by law to an executive department or agency, or the head thereof, or 2. The functions of the Director of the Office of Management and Budget relating to budgetary, administrative, or legislative proposals. B. This order shall be implemented consistent with applicable law and subject to the availability of appropriations. C. This order is not intended to and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States, its departments, agencies, or entities, its officers, employees, or agents, or any other person. It is vitally important that the International Holocaust Remembrance Alliance working definition of anti-Semitism not be incorporated into Title VI of the Civil Rights Act of 1964. Contact your senators and demand that they vote against this unconstitutional legislation which privileges one chosen group above all others while violating the free speech rights of everyone else who enjoy no such selective privilege. The essence of the bill itself demonstrates the need to publicly express the speech it would suppress. An act to provide for the consideration of a definition of anti-Semitism set forth by the International Holocaust Remembrance Alliance for the enforcement of federal anti-discrimination laws concerning education programs or activities, and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Section 1. Short title. This act may be cited as the Anti-Semitism Awareness Act of 2023. Section 2. Sense of Congress. It is the sense of Congress that 1. Title VI of the Civil Rights Act of 1964, 42 U.S.C. 2000D, etc. prohibits discrimination on the basis of race, color, and national origin in programs and activities receiving federal financial assistance. 2. While such title does not cover discrimination based solely on religion, individuals who face discrimination based on actual or perceived shared ancestry or ethnic characteristics do not lose protection under such title for also being members of a group that share a common religion. 3. Discrimination against Jews may give rise to a violation of such title when the discrimination is based on race, color, or national origin, which can include discrimination based on actual or perceived shared ancestry or ethnic characteristics. 4. It is the policy of the United States to enforce such title against prohibited forms of discrimination rooted in anti-Semitism as vigorously as against all other forms of discrimination prohibited by such title. And 5, as noted in the U.S. National Strategy to Counter Anti-Semitism issued by the White House on 3 May 25, 2023, it is critical to A. Increase awareness and understanding of anti-Semitism, including its threat to America. B. Improve safety and security for Jewish communities. C. Reverse the normalization of anti-Semitism and counter anti-Semitic discrimination. And D. Expand communication and collaboration between communities. Section 3. Findings. Congress finds the following. 1. Anti-Semitism is on the rise in the United States and is impacting Jewish students in K through 12 schools, colleges, and universities. 2. The International Holocaust Remembrance Alliance, referred to in this act as the ICRA, working definition of anti-Semitism is a vital tool which helps individuals understand and identify the various manifestations of anti-Semitism. 3. On December 11, 2019, Executive Order 13,899 extended protections against discrimination under the Civil Rights Act of 1964 to individuals subjected to anti-Semitism on college and university campuses and tasked federal agencies to consider the IHRA working definition of anti-Semitism when enforcing Title VI of such act. 4. Since 2018, the Department of Education has used the IHRA working definition of anti-Semitism when investigating violations of that Title VI. 5. The use of alternative definitions of anti-Semitism impairs enforcement efforts by adding multiple standards and may fail to identify many of the modern manifestations of anti-Semitism. 6. The White House released the first-ever United States national strategy to counter anti-Semitism on May 25, 2023, making clear that the fight against this hate is a national bipartisan priority that must be successfully conducted through a whole-of-government and society approach. Section 4. Definitions. For purposes of this act, the term's definition of anti-Semitism, 1, means the definition of anti-Semitism adopted on May 26, 2016, by the IHRA, of which the United States is a member, which definition has been adopted by the Department of State, and 2, includes the contemporary examples of anti-Semitism identified in the ICRA definition. Section 5. Rule of construction for Title VI of the Civil Rights Act of 1964. In reviewing, investigating, or deciding whether there has been a violation of Title VI of the Civil Rights Act of 1964, 42 U.S.C. 2000D etc. on the basis of race, color, or national origin, based on an individual's actual or perceived shared Jewish ancestry or Jewish ethnic characteristics, The Department of Education shall take into consideration the definition of anti-Semitism as part of the department's assessment of whether the practice was motivated by anti-Semitic intent. Section 6. Other rules of construction. A. General rule of construction. Nothing in this act shall be construed 1. To expand the authority of the Secretary of Education. 2. To alter the standards pursuant to which the Department of Education makes a determination that harassing conduct amounts to actionable discrimination. Or 3. To diminish or infringe upon the rights protected under any other provision of law that is in effect as of the date of enactment of this act. B. Constitutional protections. Nothing in this act shall be construed to diminish or infringe upon any right protected under the First Amendment to the Constitution of the United States. Passed the House of Representatives May 1st, 2024.